During the trial, the jury would be able to hear outside noise and influences. It is a deliberate, ongoing, strategic investment to reach the potential jury pool.
I like talking. I like to reveal the truth.
The retrial for Karen Reed officially begins today, and we're bringing you live moments from court throughout the jury selection process. So how will both sides weed out the people who've already made up their minds? We'll talk about it. And the Reed defense team is adjusting to a big ruling from the court. They are prohibited from pointing the finger at Colin Albert. But trying to point the finger at Brian Albert and Brian Higgins is still potentially allowed. We'll explain. Also, the murder trial of Rachel Morin beginning today. The defendant's team is arguing that he can't get a fair trial. Well, the attorney representing Rachel Morin's family is joining us live on the program to respond. Plus, an Arizona dad charged in the hot car death of his daughter is rejecting a plea deal. But will the jury hear about his alleged addictions and public use of pornography and a failed custody battle as well? We'll discuss it. It's all coming up next for you right here on Opening Statements. Good Tuesday morning to you, and welcome to Opening Statements. I'm Julie Grant. It is time for some coffee and some court, as I like to say. Grab that cup of coffee or tea or whatever you like in the morning. It's time for my opening statement. Rachel Morin deserves justice. Today, her family will take a giant step closer to getting that justice for her. Her loved ones have been living with a nightmare since August 5th of 2023, when Rachel was viciously attacked and murdered while she was out for a jog. Rachel was so many things to so many people, and most importantly, she was a beloved mother to 5 beautiful kids. And just because our cameras aren't permitted to film the alleged killer's trial, it doesn't make the case of any less interest to us. 23-year-old Victor Antonio Martinez Hernandez shouldn't have even been in our country. He was here illegally. Police say that after he murdered a young woman in El Salvador, he crossed our border illegally in February of 2023. Detectives then say he went on to brutally assault a 9-year-old girl and her mother in California, invading their home to do it. And then police say he traveled to Bel Air, Maryland, and murdered Rachel Morin. If he did what police allege he did, then that scumbag murdering predator needs to pay dearly. As his trial kicks off, may we send our love, our light, our prayers, and all of our good wishes to Rachel Morin's family. Her life mattered, and she's the one who deserves justice. That's my opening statement. We'll have more on Rachel Morin coming up for you later this hour. Right now, it's time for your daily docket.
Would you agree, sir, that you were in love with Kate McLean?
Sorry, what?
That you were in love or had feelings for Kate McLean?
Just as friends.
Just as friends. Do you recall, and this would be on May 7th, page 1639, texting her, "I think you and I are feeling the same."
In Massachusetts, we've got testimony continuing in the murder trial of Dr. Ingolf Turks. That starts back up at 9 a.m. We'll go there live together. In Michigan, we've got the battered and burned murder trial for Linda Sturmer. That one continues today after court was dark on Monday. That one also starting up at 9 a.m. And in California, we've got the defense case resuming in the murder trial for Monica Sementilli. Court was dark all last week, so if you haven't heard about that was why. Court's going to pick back up at noon today. Now, let's talk about our top story. A big day happening in Dedham, Massachusetts as jury selection kicks off in defendant Karen Reed's retrial for the death of her boyfriend, Boston police officer John O'Keefe. Over 100 jurors have been summoned to report to court today, and this process could take weeks. Earlier this month, Judge Beverly Cannone denied Reed's request to delay the start of her trial.
I'm not going to grant the motion, all right? We have jurors coming in that were summoned months ago. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th. I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches. And we'll take it from there, but we will start April 1st with impanelment.
So Reed's retrial is going to look a bit different than the first time around. So there's going to be an extended buffer zone put in place. You know that shot we always take in front of those courthouse stairs where lots of action is? Well, that's all gone now. Also, there's a new attorney on the defense team added recently. Well, two new attorneys technically, but one of them added very recently who served as a juror. She was not a deliberating juror. She was relieved of her duties. She was an alternate, but she has been added. And she doesn't practice criminal law either, by the way, if you were wondering. All right, so who's going to be an ideal juror for Karen Reed and for the Commonwealth of Massachusetts? We have a tremendous power panel to talk about this. Let's welcome these brilliant ladies in. With me, former prosecutor Melba Pearson, retired FBI special agent Jennifer Coffindaffer, and podcaster and host of the Roberta Glass True Crime Report, Roberta Glass. Good morning to you all. Melba, I want to start with you, please. As an attorney, looking at both of these sides, who would be the ideal juror for the Commonwealth and then for the Reed team?
So good morning, ladies. And I think this is going to be a very tough one from the standpoint that you have to be basically living under a rock to have not heard about this case. So to find a juror that has not heard about this case at all is going to be virtually impossible. But what both sides are going to be trying to do is to find out whether or not the potential juror has any preformed ideas or preconceived notions as towards guilt or innocence. So anyone who is sitting there that already is like, Karen Reed is not guilty, end of, or Karen Reed is absolutely guilty, end of the story, both of those jurors would be bad people, in other words, for this particular case. And I think also both sides may be interested to know about potential jurors' feelings about law enforcement, because I think that's going to play a critical role as well. If you don't believe anything that law enforcement says because you've had negative experiences, that'll definitely influence the way that you'd be looking at the facts of this case. And also the opposite is true. If you're somebody that always believes law enforcement and has a strong feeling or attachment towards law enforcement, you might be viewing the evidence in a skewed manner as well. So those are some of the things I think both parties are going to be looking for.
Yeah, great points, Melba. Jennifer Coffindaffer, the stealth juror concern that the Commonwealth surely has, your thoughts on that, and also whether this additional attorney could be helpful in possibly picking the ideal jurors for the Reed team.
Well, good morning, Julie and panel. First of all, I think that it's going to be very difficult to avoid a stealth juror getting on. They will be practiced. We know the questions. They have been out publicly, so they can go ahead and practice what they will or will not say. What I think is really important is that the counsel really watch what and how these individuals are responding to these questions. That's going to be key to try to figure out if they're lying or not. So I'm hopeful that there will be good individuals there to scope that out. As far as the defense's brand new attorney that was on the prior jury, I don't know if she'll be really that helpful. First of all, she's not even a criminal attorney, as you well pointed out. And second of all, I think she's there more to give guidance regarding some of the points that should be made that hit home with the jurors in the previous trial.
Great points, Jen. Thank you for that. Roberta, last but certainly not least on this point about the jury selection, I wanted to ask you about something. I enjoy listening to you so much about how you really dive in and have talked a lot about illusions that have been presented in this case in particular to try to convince the public. And when you think about it, who's really in that jury pool? I'm wondering if the people who are at home, not at that courthouse, not engaging in spewing hate online, I'm wondering if those people are going to come out and present themselves as the fair-minded, honest, good citizens that you would want on a jury who aren't looking to take the case one way or another. I'm wondering if we're just not hearing from those people, if that's going to be our pool. Curious, who do you think is going to get picked for the pool?
Well, I mean, we think that everybody, when we talk about true crime, follows true crime, but not everybody follows true crime or even court TV. So we're looking for someone not who so much doesn't know about Karen Read, but doesn't have a set opinion and can look at the evidence in a fair-minded, rational way that doesn't think, what if something really improbable happened, and hasn't been touched or influenced by Karen Read and her enablers' innocence fraud campaign.
Exactly, Roberta. You want somebody who's not going to have been influenced or looking to tank the case in any way. And I'm just wondering if what we see, we see people outside, and sometimes the most obnoxious and loudest people, are not the reflection of the community. And Roberta, I'm curious, you've talked to a lot of people, done a lot of interviews and work on this case. Curious if you think what we see out there is truly a reflection of the community in Dedham.
I think some of it is. I think she does have some support, but I think it's probably exaggerated. I think it's a very well-crafted, well thought out, well-funded, certainly, propaganda campaign. I think most people, I think most people are curious about the case, and I don't think the majority are the Free Karen readers. No, not in that community. Although I do think she does have her supporters. Yeah.
Roberta, thank you for that. Excellent points. Here's what I want to do. I want to play for you all a clip that has really circulated and gone viral. Dave Portnoy, the head of Barstool Sports and the owner of Miss Peaches, who's beloved online, has taken notice of the case and started talking about it. Let's take a look.
Get ready with the Karen Read stuff. You just said she's guilty, so just get ready for that crowd. That's the craziest crowd of all.
Are you afraid of Turtle Boy?
Me? No, I'm friends with Turtle Boy and I are buddies.
I said I would not vote her guilty, but if you gun the head, I think she did it.
I think the weirdest thing of all, she's doing this right now.
She's crazy.
That's what I don't get.
She does seem fairly unsympathetic that the guy's dead.
Okay, so that was just a portion of the conversation. Melba, you were just hitting on how you have to be living on another planet to have not heard about this case, and especially after the investigation discovery doc, more and more people are digging in and weighing in on this. Would you mind speaking to the idea that I think it's often overlooked? It's okay for someone to have heard about the case or thought about it or, maybe formed an opinion. What isn't proper in having someone on a jury?
Well, what's not proper is for you to come in already with your mindset as to what the verdict is. Because remember, when you come in to a case, what you hear, what we see reported on court TV and other outlets is not the entirety of the case. You're not necessarily hearing every single piece of evidence that the juries heard in the first trial. We heard bits and pieces and all of that. So when you're actually the juror on the case, you have to have a completely open mind and listen and evaluate the evidence and compare that to the law, and then make a verdict based on that, not based off of what a podcaster said or what you heard a commentator say or whatever the case may be. Just listen to the evidence that's in the courtroom. So again, it's okay to have heard of the case. It's like any high-profile case, whether it's Diddy, whether it's Henry, Epstein or Weinstein or any of these high-profile cases, R. Kelly. You would have heard of them, but you just cannot have already formed an opinion as to their innocence or guilt.
Exactly, Melba. You can have thought about it, but once you take on that oath and that service, you have to say, okay, I'm willing to let go of anything I previously thought or might have thought I believed and just totally judge the facts on the evidence. So, to your point, Dave Portnoy could be on this jury if he could say, look, I can follow the law. I can, I might have had some opinions watching that documentary, but I'm going to be a good citizen and listen to the evidence and judge the case therefrom. All right, we're not done talking about this. Our power panel staying with us. We're going to hit our first break. When we come back, we'll talk about the big ruling that came down yesterday from the court on that third-party culprit defense that Karen Read's team has been trying so hard to put forth.
Based off of our investigation at this point, right, we have determined that there's probable cause to go ahead and charge you for what happened. Okay. That's through the air. So
Let's come out here, Christopher.
No.
It's okay.
No.
Okay, so listen.
No.
An Arizona father rejecting a plea deal in his daughter's death. We're talking about why. That's straight ahead.
Grieving widow or mastermind behind a murder.
Monica Cimentelli is accused of plotting to kill her husband.
Famed celebrity hairstylist Fabio Cimentelli.
Prosecutors say she and her lover killed Fabio to collect a big life insurance policy.
The defense may say she's a bad woman, but she wouldn't be involved in a murder.
It's a whodunit Hollywood story, but will there be a twist that no one sees?
The Celebrity Stylist Murder Trial, today, only on Court TV.
We're solely seeking to introduce the crux of a third-party culprit defense, which is evidence of motive, opportunity, and means, all of which Brian Albert, Brian Higgins, and Colin Albert had.
Now let's talk about a key ruling ahead of Karen Reed's retrial. This could be tipping the scales in jury selection even. Judge Beverly Cannone ruling that the third-party culprit defense that the defense wanted to do with young man Colin Albert has been denied. They cannot try to point the finger at him. Now, the judge said this is because they failed to show there was any evidence that Colin had any motive, intent, or opportunity to kill Officer John O'Keefe. What's more, there was no evidence he was even at 34 Fairview at the time that John O'Keefe was there. The judge said, in citing Karen Reed's right to a fair trial, that she is going to potentially allow them to point the finger at Brian Higgins or Brian Albert if and only if they can support their claims. She wrote, quote, counsel cannot mention potential third-party culprits in opening statement, but will be given the opportunity to develop the theory throughout relevant evidence at trial. So she's taking that incremental approach that she did last time, essentially saying, if you can put forth the evidence to substantiate your claim, then in the end, I'll give you the jury instruction on it. But remember, the first time, they couldn't do that. They couldn't do that, so they didn't get the jury instruction. Let's take a look back at the first trial. Alan Jackson arguing about the defense theory, accusing Colin Albert as being a suspect.
The Massachusetts State Police should have, if they were doing their due diligence, they should have investigated this young man. They should have investigated every single person that was in that house, in or around the home of where John O'Keefe was found, the Albert home, and they didn't. They did nothing to investigate whether or not there was someone in the house who tended to fight, who wanted to get in physical altercations, who had a propensity to get in physical altercations, who was a fighter by nature, who threatened to fight, who threatened violence. That's what this young man has indicated he does constantly. I'm surprised he didn't show up in this hearing with busted knuckles.
So does this go to your third-party culprit defense?
It goes to both. It certainly goes to Bowden, but yes, it also goes to our third-party culprit defense as well. This is a focus of, I believe, this should be a focus of the jurors' attention in terms of, is there a third party who could have done this, that evidence points to, that may have done this? Absolutely. This evidence, what we now have, points directly in that it's focused in that direction. So yes, both it should have been investigated, and Colin Albert is somebody that the jurors should focus their opinion on or their attention on to determine whether or not he could have or was involved in the death of John O'Keefe.
I'll tell you what sickens me. That young man wasn't even there. And the harassment and the torture and the bullying that he experienced because of these wild, unsubstantiated claims were disgusting. Absolutely disgusting what happened to that young man. Let's talk about this some more. Let me bring in Jennifer Coffindaffer, Roberta Glass, and want to welcome in attorney David Bruno. Jen, let me start with you, please. You know a lot about this. This claim about Colin Albert the first time around didn't come without consequences, did it?
No, it didn't. I mean, this young man wasn't able to go to college because of the harassment he was suffering. He had an opportunity to play football. He wasn't able to do that either. So concerned about the harassment, about being followed, about being really tortured for being a murderer at 17 years old. Yet he wasn't even at the location when Karen and John O'Keefe arrived in the SUV. Also, John O'Keefe never entered, and again, he wasn't even there. And Julie, they showed photos of Colin Albert's knuckles on February 26th, not showing the photo of his knuckles on February 9th, and which were clean. It was just absolutely cool what they did.
Right, right. And we know John O'Keefe was killed by someone in January. And if they had shown the photo where his knuckles were fine on the 9th, Jen, you're right, that wouldn't have led to all the confusion with the jury that Judge Cannone is preventing this time around. I tell you what, it makes me nauseated what happened to that innocent young man. And I think he's got a nice lawsuit that he can bring. David Bruno, would you speak to that, please? Oh, we don't have your audio, David. That's okay. Let's see if we can get you repaired. I'll come back to you.
Oh, I'm here.
Okay.
My apologies.
Yeah, back up, my friend.
I
Go ahead.
see it a little differently, Julie, respectfully. I see it through the lens of the defendant. You know, I am a former homicide prosecutor. I sit in the defense chair right now. And the third-party culprit angle is really a constitutional right. And when it's curtailed, it really bothers me. I do understand that there's some factual issues surrounding Colin that would be able to play out in front of the jury. The fact finder could assess the credibility of the particular evidence. Curtailing the Higgins and Albert opening statement too bothers me a little bit, you know, because I think there's a little bit there. Obviously, the injuries on the decedent and how they came to be versus whether or not it was an animal versus whether or not it was the taillight. I mean, that's always in question. And then finally, Julie, also, what she also is not allowing is the arguments about the deficiencies in the law enforcement action. That's curtailing again. They have a retired FBI agent that is there to talk about what a investigation should be, the type of investigative tactics and leads they should be following up, and they're also prohibited from getting into that angle. These are three big blows to the defense. It's going to look very different than the first trial, and it may end differently as well.
David, appreciate your point of view as always. Roberta Glass, let me go to you next, please. Your thoughts on this?
Well, it was quite ridiculous to hear David Yannetti argue in court just because there's no evidence that something happened with any of these three alternative suspects doesn't mean we can't use them. And that's because based on he used his own case. This was the case Commonwealth versus Finney, the case of Marion Alexander's killer, Roland Douglas Finney, who David Yannetti and his sister Tanis got out of prison after a decade after he served a decade or more than a decade in prison, on some very improbable and laughable suspects, and he created precedents with that quite disturbing bamboozle of the courts that he did with getting Roland Finney out. And just like Karen Reed, no one else has been charged or convicted of the murder of Marion Alexander, and just as with no one else has been charged or convicted of the murder of John O'Keefe.
Right.
It's very similar.
Right, Roberta. And, and let's talk about that because Karen Reed was, blowing the horn as loud as she could about her case when nobody knew who she was or what her trial was. She and her attorney went to the federal government and said, you got to investigate this. There's corruption everywhere. Somebody else did this. My client's being framed, yada, yada, whatever was said. And they found nothing. They found she wasn't being framed. They didn't indict anybody. They essentially, their lack of finding any other evidence that anything else went wrong shows that they got the right person. Jennifer Coffindeffer, in light of that, how successful do you think this third-party culprit defense that they want to put on, and though they might be allowed to do something with the two Bryans, is going to be?
I don't think it's going to be successful. Look, to your point, this is rumor. This is speculation. There's not one iota of fingerprint evidence, of DNA evidence, of video evidence, of any evidence that they had anything to do. They have no motive, nothing to do with his death. So it's preposterous.
I couldn't agree more. You know, Hank Brennan has spoken up and articulated very well how, you know, third-party culprit, and David Bruno, let me go to you on this. It's not without rules, right? You can't just say, oh, I think I'd like to point the finger, you know, at Julie Grant because I feel like it. No, there has to be all sorts of things substantiated in Massachusetts, motive, intent, opportunity. Knowing that, how do you think that this is going to play out? I mean, truly, David, with Brian Higgins and Brian Albert, these two veterans who served our country, have served in law enforcement for many years, you know, who weren't even near him that night when he was dropped off at the house. There's no evidence John O'Keefe ever set foot in the home. How do you truly think this is going to play out, David? Do you think it's going to be the same thing as last time, like a big nothing burger?
Yeah, we'll see. Hung jury maybe, or guilty. I can't see them acquitting her. You got to be careful about what you are trying to prove as a defense, because you don't have to prove anything. It's proof beyond a reasonable doubt. It's all on the prosecutor to prove the case. But when you start to go after two individuals like they have, their credibility is going to be at issue too, and we'll just see how this one falls.
Yeah, yeah. Roberta, let me go to you. A last word, please, on Karen Reed and all the talking that she's been doing all over the place. How do you think that's going to affect the trial?
Oh, I think she's turned out to be very unlikable. I think she's turned a lot of people off.
Mm-hmm. Yeah, I agree. We'll see what happens with the jury. It's wonderful having you back on the show. Check out Roberta's podcast, The Roberta Glass True Crime Report. I'll be listening, and we'll have you back soon. Agent Coffindeffer, thank you so much for your time. And, oh, that little cutie pie in your shot. I see a cute little kitty cat. Oh, my gosh. All the animals are always welcome on opening statements. And, David, you're coming with us. We thank you for that, too. Just ahead, we're going to talk about another big case we've been covering, the Rachel Morin murder case. Her family attorney and friend of the program, Randolph Rice, is joining us live. Plus, the Arizona dad accused in the hot car death involving his daughter. He rejected a plea deal. So we're going to dig deeper into his prior bad act evidence.
I will do whatever I can to keep her memory alive and to be there for her children, because she's irreplaceable. She was 1 in a million.
This morning, we're shining a spotlight on the Rachel Morin murder case as jury selection kicks off today. The mother of 5 was found dead on a hiking trail in Maryland in August of 2023. It took months, but a suspect was finally arrested. Victor Martinez Hernandez, who entered the country illegally from El Salvador, was taken into custody in Tulsa, Oklahoma last June. He was charged with murder, with rape, and with kidnapping. The Department of Homeland Security says that Hernandez was expelled from the United States not once, not twice, but on 3 prior occasions. The defense made a whole bunch of last-minute requests, including jury sequestration, which was denied. Let's bring in the attorney for Rachel Morin's family, Randolph Rice. Randolph, good morning to you. How is the family holding up this morning?
Yeah, they're very nervous and obviously anxious about this, but as Patty said yesterday, you know, it's in God's hands. She understands that things happen for a reason, and she's sort of accepted the fact that God is going to take care of what's going to happen the next couple of weeks. So she's at peace with it. I know the rest of the family certainly is looking forward to opening statements on Friday.
I'm sure, Randolph. Tell me, the children, I know, of course, we want to be mindful of their privacy, but everybody wants to know, are they okay? Are they in good hands?
Well, each of them have, their fathers there taking care of them, and each one are grieving in a different part of the process. You've got ages ranging from 18, 19 years old down, I believe, 8 now. So they've all sort of been grieving in a different part of the process. We don't really think that they're obviously not going to be attending the trial because just of the graphic nature of the images that will be shown during this trial is something that you just can't, unsee.
Right, Randolph. Our hearts go out to them. Give them our love. I want to show you some of the proposed jury questionnaire, geez, I'm having a hard time getting my words this morning. Yes, the proposed questions for voir dire. Randolph, I was telling my team off camera, I'm in the fog this morning. All right, so we have the jurors' knowledge of the Morin family, the use or the proximity to the Mon Pa Trail where Rachel was killed, and donations to the Morin family's GoFundMe. We also have participation in podcasts about the case, comfort with viewing graphic evidence, and views on race and ethnicity. Randolph, your thoughts on the importance of some of these questions for those prospective jurors?
Yeah, so yesterday they had a pretrial conference where they debated between the state and the defense all of these 50+ different questions. A lot of these were coming from the defense. They wanted to expand that voir dire, that questioning of the jury panel. And really what Judge Curtin, the Harford County Circuit Court judge who's overseeing this case, sort of shut the defense down and said, look, I'm not going to start diving into these very specific or sometimes very broad questions, because she called it essentially a fishing expedition. The defense was trying to gain more information about the jurors so they could use that in their selection process. So what she really said was that I'm going to ask a very general question. Have you heard about this case? And if so, how have you heard about it? And then I will allow you to follow up with questions of that juror to determine if they can be fair and impartial.
Randolph, thank you for that. We know that the defendant's lawyers have made the argument that there's no way he can get a fair trial. What do you say to that?
Yeah, I mean, look, there are over 200,000 potential jurors in Harford County, and I said this yesterday to the press. I oftentimes will ask people, hey, have you ever heard of the Rachel Morin case? And I'm shocked how many people have not. So I think it's going to be very easy for the judge, the state, and the defense to find 12 people in Harford County who, and it's not that they haven't heard of the case, it's that they may have heard of it, but can they be fair and impartial? Can they listen to the evidence? Can they hear the witness's testimony? And can they come away with it and apply the law and find beyond a reasonable doubt is either to his guilt or innocence?
Right. Randolph, harken back to your experience as a prosecutor. For many years you served in that role. Are you at all surprised that this guy is going to trial on these very bad facts?
Julie, that is a great question. And early on, I thought that he might decide to take a plea. We don't know the details of what the plea was. We know there was a plea offered early on when the state was trying to prepare their case, and we certainly don't know. But there would have been an incentive there. Remember, the top count and the most serious penalty in this case is life without parole. So there is presumably was a chance of getting parole. We're not sure of that. But certainly now he's facing the possibility of life without parole. So I'm a little shocked. But at the same time, we talk about it often on the show, defendants want to take their chance to see if they can possibly get lucky and find one juror who says, I just don't find enough evidence there.
Exactly, Randolph. Well, we're certainly sending every good wish to Rachel's family as they have to sit through this, because just sitting through that is going to be another trauma for them, unfortunately. Randolph Rice, you're the best. Thank you so much for coming on today. We'll look forward to having you back very soon. Coming up next here on Opening Statements. An Arizona father accused in his daughter's hot car death is heading to trial. This is after he rejected a plea offer. We'll talk about what could tip the scales, though, when the case goes.
Daybell.
Already convicted for the murders of her children.
Doomsday cult mom is now lawyer Lori. She's representing herself.
On charges of conspiring to murder her fourth husband.
She said, I can murder you now.
She really thinks she's equipped to try this case.
She appears very sure of herself.
I have real trial experience.
It's going to be a strange trial. We'll see how it plays out.
The Cult Mom Conspiracy Trial, this week following jury selection, only on Court TV.
Now for what's trending in true crime, an Arizona dad rejecting a plea offer for the hot car death of his 2-year-old daughter. But when you hear his backstory, you're going to wonder why. Christopher Schultes will go on trial for first-degree murder. His daughter Parker died in the driveway of their home just outside of Tucson, Arizona last July. Schultes, whose appearance has changed dramatically, really dramatically since the time of the incident, admits leaving her in the car while he put groceries away and then decided to play some video games. Let's take a look at police body camera footage of him talking with deputies.
How long was she sleeping in the car out there?
I want to say it was no more than 30, 45 minutes. And I don't think their air was off that entire time. I think there was a time in between. I had checked on her last. It was still running. She was still sleeping. And then when I went back out, the car was off.
The plea offer would have required him to plead guilty to second-degree murder, which carries a sentence of anywhere from a minimum of 10 years to up to 25 years in prison. But now he's looking at life in prison, potentially. So we're asking, why reject the deal? Let's bring in our legal eagles. So happy to have on the show this morning, Melba Pearson and David Bruno. Okay, Melba, to you first here. What do you think about this guy rejecting this?
I think it's almost a matter of ego. Like, he does not want to say that he murdered his child. He's standing by his assertion that this was a terrible accident. And by pleading guilty to second-degree murder is basically saying it's not an accident. So I think that's why he's trying to roll the dice in the hopes that maybe the jury may come back with a manslaughter as a lesser included offense. Because again, he's saying that he's more negligent rather than he intentionally tried to kill his child or he was just reckless in the way that he treated his child. That's my guess at this juncture from everything that we've seen about him. But I don't think that this was the best call on his behalf because he's not going to be very sympathetic to the jury, unfortunately.
Agreed, Melba. Thank you. David Bruno, why do you think this guy rejected it?
Believe it or not, again, I'm a little different here. Look, I do not think that first degree is provable whatsoever. It requires premeditation, deliberate, intentional actions. And initially, too, the prosecutor didn't charge the first degree. It was the grand jury. When the prosecutor presented it to the grand jury, those lay people, the grand jury's a little loose, too. It's not as, they don't get the instructions like the petit jury does as well. And they found it on their own to go up to the first degree. So I just don't think that the prosecutor is going to be able to prove deliberate premeditation, intentional actions. And then it falls down to what was offered. So essentially what the prosecutor's doing is offering what I believe the jury would be the top count in the petit jury. And then there's this other option of the lesser included that the defense could try to argue that it was not extreme disregard for human life, because that's how you get to the second degree. It needs to be reckless actions showing extreme indifference to the human life. So with that being said, the state's got some good evidence, though. I mean, he's got a statement that says that he knew that the car would shut off 30 minutes. It was 109 that day, and she was in that car for 3 hours. But I could see the decision. It still will be a tough case for the defense, however.
David, I love the point you made. You know, we all know this as having served as prosecutors. You know, you want to entice someone with an offer, not offer them, you know, the indictment, because usually it's like, well, yeah, I know I can plead to the indictment. So I hear what you're saying, that maybe if they would have offered manslaughter, let's say, or something, because this man has suffered tremendously in losing his child. What's worse than that? I don't think any punishment could be worse. So appreciate it. Let's talk more about his background, because it had us floored when we were talking about this in our newsroom, why he would reject the deal knowing this. So court records that we've poured through indicate he lost custody of his oldest daughter. He also would allegedly shoplift beer. He also would abuse alcohol and cocaine and watch pornography in public, not in his home, in public. Okay. Now, this guy clearly was shocked at how he was being treated by deputies the day of his daughter's death. Let's go back to that moment and watch together.
Oh my God. Oh my God. I don't want to feel like we're intruding, but we're going to have to stand by with you for a while. All right.
Is there a reason why?
So any death, we have to treat like a crime scene. know this is extremely difficult for you. This is a normal process that we have to follow through with. I don't want you to be blindsided by anything, but that's what's going to be going on for right now, okay?
So I'm being treated like a murderer?
No.
I just lost my...
No. I know that.
All right, so what, if any, of that prior bad act evidence could come in to the case? He's got some concerning stuff. Melba, let me go back to you.
Well, I think the custody issue is going to be really problematic because that directly ties into his parenting style, his ability to parent. And so now if there's been a history of him abandoning his children in the past, that is definitely something that can play into here to show that this wasn't just an accident. This is just something he normally does and that he just doesn't really care about his children, and that's the argument that could be presented. Also, the drug use might come in depending. Again, giving that legal answer, it all depends, because again, is he alleged to have been using drugs at that time? Is that the reason why he was so distracted for that 3-hour period of time? Same thing with the porn addiction. Was it that was the thing that took him away from paying attention to the fact that his child was in the car? Or is this just something that we're going to throw out there just to try to sully his reputation? That's the big difference as to whether or not that's going to be admissible.
Excellent points, Melba. Thank you. David, what would you be most concerned about? Let's say you're on the defense side of this case.
Well, look, I mean, it's the prior bad acts that we were just talking about, right? So generally speaking, we do not want juries deliberating on the guilt based on propensity to commit crimes or being a bad person. So there's a rule of evidence. Generally, it's 404B. And what that allows is for prosecutors to use those if it's narrowly tied and relevant to the particular case. Here, Julie, there's another wrinkle to this. And allegedly, I read reports that the defendant was in a convenience store earlier that day. He took 3 cans of beer into the bathroom, chugged 2 of them in the bathroom, and left without paying 1 on the day in question, also leaving his daughter in the car during that. So if that is true and they could admit that particular evidence, that would be narrowly tailored to, and it would go to his state of mind that is now under the influence, while also going in, playing video games, putting away garbage or the groceries, and then leaving the daughter out there. If true, if that's evidence that comes in, that's very, very difficult evidence for the defendant to explain.
You're so right, David. I think his goose is going to be cooked if that comes in. You know, I mean, talk about irresponsible parenting. I mean, my gosh, he's more concerned about drinking and video games than his beautiful child. Melba, if you're on the side of the prosecution, are you confident going into this case?
Well, I mean, you can never be 100% sure, right? And that's one thing that I've always, you know, when I was trying cases, that I was very clear to explain to the next of kin that, listen, you can't guarantee what a jury's going to do. You're going to put your best case forward, but clearly there is some strong evidence to work with here. But you can never guarantee what, you know, a group of strangers are going to do in the jury box. But I'd say the prosecution has a lot to work with, and that the defendant is really on the back foot on this one.
Yeah, definitely. We'll see. You know, David Bruno, tell me, do you think that we could even see more negotiations? I know we don't have a lot of time here, but maybe it's not over with a plea agreement.
Absolutely. Anytime. I mean, I've seen cases plea out in the middle of trial. There's always hope. Maybe the prosecutor comes down. Maybe the defendant gets second opinion on it, and then who knows? It could always happen, though, Julie.
Right. You're right. I know there's nothing worse sometimes after you pick your jury, you just get started, you do opening statements or something, and then you got it pleading out. All right. Well, we'll see.
It gets very real for the defendant when that jury comes in.
You're exactly right. Suddenly, sometimes they start thinking a little more rationally. I know. I've had it happen. You two are the best. Melba Pearson, David Bruno, thank you kindly. We're going to hit a break. Thanks for being with us for opening statements. Court TV Live is next.